and welcome to this webinar on video conferencing in Indian courts. I'm Leah from DAKSH. DAKSH is a civil society organization based in Bangalore which works on judicial reforms and access to justice. We've recently published a draft paper on the subject of video conferencing in India, which is available on our website. This is the fourth paper in our series on the next generation justice platform. During the course of researching for this paper, we realized that the subject is really complex and we needed to engage very deeply with it in collaboration with experts, judges, lawyers, and academicians, and also users of the system who are the citizens. In the last month, as all of you know, the way we have structured the webinar is we will begin with a short presentation by my colleague Aruna. Then we will have introductory remarks by the speakers and a discussion with them. After that, we will take questions from the audience. Just a note for the audience, please don't use the polls option for the questions. Click on Q&A on the left side and type your questions. We will select a few questions that we will ask our speakers at the end of the discussion. Over to Aruna for the presentation.
Good evening, everyone. I'll just... Yeah. Am I audible?
Yep.
All right. So this is just a short presentation on the paper that we have done, sort of to set a context as to what the paper contains. So the primary objective of the paper was to see how can the use of video conferencing be expanded, given the recent pandemic that we are in, and further to see how it can be used even after for a longer term, to see the challenges that the courts may face while using the video conferencing. And the paper also focuses on some of the guidelines and what should be included in those guidelines with regard to the use of video conferencing in court. So this is the broad objective with which we went about writing this particular report. Before I begin talking about the report, this is the fourth paper in a series of next generation justice platform that DAKSH has been working on over the past few months. So the details of those reports can be seen on DAKSH's website. So this is a subset of that particular series that we've been working on. So the paper begins by looking at the timeline of video conferencing in Indian courts. So it started in 2002 in the Supreme Court, where it was allowed to be used in civil courts, and then through that, over the span of several years, it was expanded to criminal courts, limited to a limited extent in family courts, and in various tribunals it is used today. As per the recent data, around 488 court establishments and around 342 prisons in the country have video conferencing technology available. And so this is sort of a timeline as to how video conferencing came about in the Indian courts. The E-Committee of the Supreme Court has also initiated certain pilot exercises to use video conferencing in courts and to see how it can be implemented. So apart from video conferencing, the first things that need to be kept in mind is to also see the related processes with regard to video conferencing. For instance, the report looks at e-filing, electronic evidence management, document and case management, and improved listing practices. That are some of the related processes that also need to be developed along with video conferencing. Some of these options are available on e-courts, but certain options such as electronic evidence management are still to be launched for the e-courts project. Nonetheless, the report tries to say how these processes need to be kept in mind while looking at video conferencing. So the paper next looks at the architecture of how the virtual court would look. So this is sort of deconstructing the various access levels that the stakeholders would have. So for instance, the first level, of course, is the judge, the bench clerk, and the typist. And the next level is the petitioner, advocate, and the petitioner, respondent, advocate, and the respondent. And then the subsequent levels, you have the police, and the final one, you have the public and media. So these are the separate, different hierarchy of access levels that are given in the report to understand who the stakeholders are and what are their roles in this particular process. Next, the report looks at the architecture of the virtual court. It sort of gives how the screen should be, what are the features that must be available with the judges as well as with the respondents or the accused and the petitioner. For instance, there should be a channel through which the accused and the advocate can sort of interact separately on the video conferencing platform mind while discussing virtual court and video conferencing, and that both the parties should be able to send documents, should be able to look at whatever is being discussed. The judge should know who's discussing, is it the petitioner or is it the respondent. So these are some of the attributes that are important when we discuss video conferencing. Another important aspect that the report talks about is the due process concerns that need to be kept in mind while discussing video conferencing. For instance, looking at vulnerable witnesses, looking at how to design features to help people with physical disabilities, or how to overcome linguistic barriers. Another thing that the paper focuses on is the privacy concern and the data and the privacy concerns that revolve around the use of video conferencing in courts. Also, other safeguards such as fairness in criminal cases, presumption of innocence, right to counsel. Even in video conferencing, it needs to be ensured that the accused has a counsel and that he doesn't go without representation. Lastly, the paper looks at sort of international comparison it does an international comparison across different countries to see how video conferencing is being used in other jurisdictions. So we looked at USA, Canada, Australia, and UK, and there were a bunch of categories with which we compared each of these countries. So as we can see, video conferencing is used with judicial discretion in all these countries. Importantly, if you look at the second column, you can see that separate link is available between lawyers and clients. So there is a separate communication channel in most of the countries. For instance, USA has it, and Australia also has it. So you can have a separate channel. In terms of the networks being used, most of them use third party. For instance, USA uses Skype and Zoom. Australia uses, again, Zoom, WebEx, and some other third party apps. And then again, you can see there are user manuals available, there are interpretation facilities available, transcripts are available. So sort of gives you a comparison of how it's being done across the globe and in other jurisdictions. The paper also talks about the technology that can be used for the video conferencing, and sort of gives you a workflow of video conferencing process in courts. It discusses about the hardware, software, and everything in relation to how the technology can be used and what technology can be built to use video conferencing to its best optimal capacity. Lastly, the paper ends with the implementation timeline. It tells one of the primary ways with which we focus in the paper is to use pilot projects to see how video conferencing can pan out in courts, and use the learnings from these projects to sort of implement video conferencing in courts. And it also gives you a timeline of how and when can video conferencing be fully imbibed into the system. And also it speaks about draft framework of rules which need to be brought out for video conferencing. So a lot of high courts are coming up with rules for video conferencing. So the paper sort of gives a framework of what and all needs to be included in those draft rules. I'll just end my slide quickly by the discussion points that the paper raises. So some of the discussions are: can and should video conferencing be made a default mode in specific circumstances? And if yes, circumstances such as outstation witnesses, when one of the witnesses is outstation, or let's say in heinous crimes against women, or in POCSO cases, or in consumer courts, commercial courts, and tribunals, can video conferencing be made to a certain extent a default mode? So can that be done in future? Other questions that the report raises are: what are the legal and technological measures that can be taken to protect individuals' data and privacy, given the third-party apps that are being used? How can we sort of align these ideas? Another thing that it raises is: should legal aid authorities expand the scale of the usage of video conferencing? So that is an important question that again is raised. And how do we ensure that, and this is the broad question that comes up, how do we ensure that video conferencing be made more citizen-centric, given the digital literacy and given all the other factors? How do we ensure that video conferencing is made more citizen-centric? So these are some of the questions that the report aims to raise. So thank you, and I hope the PPT helped in understanding what the report briefly speaks on. Thank you.
Thank you, Arunav. It is with great pleasure and a little trepidation that I'll now introduce our three distinguished speakers. So first we have Justice A.K.Jayasankaran Nambiar, who is a judge of the Kerala High Court. He is an alumnus of Oxford University and the Government Law College, Ernakulam. He commenced practice as a lawyer in 1990 with Menon and Pai Advocates, a leading law firm in Cochin, and specialized in constitutional law and taxation. He was designated as a senior advocate of the Kerala High Court in July 2011. Our next speaker is Mr. Jamshed Mistry. Mr. Mistry is a lawyer with experience in international law, media and entertainment law, medico-legal issues, and public interest causes. He is also the founder of the International Legal Alliance, a virtual network of lawyers around the world. He is a member of the Bombay Bar Association, the Intellectual Property Rights Practitioners Association, and an associate member of the Canadian Bar Association. Harish Narasappa is the co-founder of DAKSH and one of the founding partners of Samvad Partners. His practice covers general corporate law, mergers and acquisitions, private equity, venture capital, corporate financing, dispute resolution, and commercial real estate. Harish is also the author of a book titled Rule of Law in India, A Quest for Reason, and a joint editor of DAKSH's two pioneering reports, State of the Indian Judiciary and Approaches to Justice. We will now begin by inviting Justice Nambiar to make his opening remarks. Sir, over to you.
Thank you, Leah, for those nice words of introduction. A warm good afternoon to all. It's a bit strange, I must say, that addressing people who you don't see. But I'm sure that there are many who are hearing this. And warm good afternoon to my fellow co-panelists, Harish and Jamshed. I don't see myself as a person who can talk to you on the technical aspects of video conferencing. So let me share some of my thoughts on the subject, as also my personal experience with using the said technology during the lockdown period in Kerala. It comes as no surprise that the non-availability of support staff and infrastructure during the lockdown period forced us to resort to some make-do procedure for hearing urgent cases, which was a growing need. Now, this essentially meant that we had some IT personnel helping us with the technical aspects of this, and a few personnel secretaries multitasking as stenographers and court officers. To cut a long story short, at the very basic level, we found that the pleadings could be electronically filed through an email that was sent to a designated mail account. The document would then be scrutinized for defects such as clarity, etc., and thereafter locked electronically to prevent further modification. The document so locked would then be put in an electronic Dropbox from where it could be viewed by the judge, the litigant, the lawyer, and everybody else who had to have access to the document. The registry that was functioning at that time, the notional registry, would then draw up a cause list of all the cases that were accepted by the registry. And after drawing up the cause list, that would be published in the High Court website. The cause list would also contain the link that would take the participant to the video conferencing room or the virtual court the next day when the case was taken up. The first day of video conferencing during the lockdown period, I must say, when we entered the virtual court, it was like the first day in play school. There was so much noise coming from the microphones of the various participants, and it was a pandemonium of sorts. But the good part of it was that we were able to bring it all under control within 10 minutes. And why I stress on that is just to inform all that this was not rocket science for us, and we could actually convince people to do the correct thing so that there would be some order and less chaos inside the court hall, the virtual court hall. And I must say it is good for the IT team that we have, and also a significant role that was played by the lawyers who managed to absorb the new technology very fast, because all of us were new to this system of video conferencing, and it was very quickly absorbed by the lawyers, who then quickly learned the etiquette that had to be followed while video conferencing. The audio function of all but the persons who were participating in the case would be muted so as to cut off any unwanted sounds, and the hearings would then take place just as in any other, as in an ordinary court. Now, after the hearing, the order would be, we would dictate the order in open court, and the secretary would then type out the same and then put it in a format and then share it with us for our approval. Once we approved it, the secretary would then affix the digital signature of the judges, and we had already obtained that by the time. And the digital signatures would be put to the order. The order would then be uploaded digitally. Would be uploaded to the website of the court, from where the parties concerned could download the same. When we were resorting to this procedure, of course, we had to overcome the initial hurdle of complying with the normal procedure which we would adopt for getting the files into court and the registry. So what we did was we took an undertaking from the lawyer or the litigant concerned that immediately after the lockdown was lifted, he would file the pleadings in the physical format, the regular format, and pay the court fee, etc., which was applicable. So with this undertaking, we resorted to this make-do procedure, which to its credit has to be said that it was very fast, it was very effective, and I think a lot of the lawyers were very happy with the fact that they could get the case listed before a judge in record time, and more importantly, once the judge had pronounced the orders, they could get the order or the judgment within record time as well. Now, using this procedure, we were in the High Court and we were handling basically urgent writ petitions and bail applications. Although bail applications are normally considered by single judges in the High Court, because of the peculiar situation we found ourselves in, it was a division bench. There was just one division bench that was to cater to the urgent cases that were filed during the pandemic period. So the division bench handled about 40 cases on an average per day in one court using the said infrastructure. And the proceedings would last for about 2 hours. And the most notable feature of this proceedings was that every participant functioned from his or her own home so as to adhere to the social distancing norms that were in place. Now, of course, this was a temporary arrangement to tide over the lockdown period. And the question does arise as to whether we are ready to take this to the next level and make it a regular alternative to the usual court proceedings, and maybe still later make it the default mode of court proceedings. If you were to ask for my opinion, from what little experience I have with this, it would definitely be a yes to consider moving on to video conferencing as a regular alternative to the present system. And by that I mean we continue with the present system, but also experiment and explore the possibility of using video conferencing in certain category of cases as an alternative to the present system. I believe, and this I speak from experience, my own experience as well as experience of my colleagues, that the transition is only a matter of mindset, and it is quite easy once you come to grips with the technology. Now, the draft white paper prepared by DAKSH, I've gone through the entire thing. I must say it does provide a fascinating roadmap for the future of litigation in our country. Congratulations to fellow panelist Harish and his brilliant team for this voluminous document, and I think there's a fair amount of research that has gone into it. I'd only caution Harish because somewhere in that document I read that when it comes to prioritizing various things for the video conferencing module, you seem to have suggested that transcription of court proceedings is to be given a low priority. I don't know whether that would go down well with the other co-panelist, Jamshed, because I know for a fact that he has been championing the cause of transcription of court proceedings for quite some time now. And to be told that that is low priority in the roadmap for the future, well, I'll leave it to Harish and Jamshed to sort out that dispute either during the course of this webinar or maybe thereafter. Now, before I conclude my opening remarks, when I went through the draft white paper, there are some things as a layman which I would like to get answers to, especially either from the co-panelists or from the audience. I find that the present attempts at migration to the video conferencing module appear to be taking the path of replicating the physical court procedure to a virtual court. I'm curious to know as to whether this necessarily has to be the case. And why I ask that is because the new technology which we are going to embrace will render redundant a lot of the earlier procedure that we are used to in physical courts. And I feel that we don't therefore need to make a provision for such an outdated procedure in the change scenario. I'm also apprehensive that in the near future, artificial intelligence is going to play a significant role in our courtrooms. And therefore, we do require a paradigm shift in our approach when we frame rules of procedure for virtual courts. Simply adding on to the existing procedure and trying to make it or adapt it to a new module, the video conferencing module, may not, in my opinion, be the solution. I feel that we may have to look at a virtual reframing of our procedural rules, our civil rules of practice, the criminal rules of practice, the Evidence Act, to actually bring about a system of rules and regulations which will guide or be our guide for the virtual court. So with that short introduction, and let me hand the proceedings back to Leah.
Thank you, Justice Nambiar. Actually, your thoughts echo with our research on the Next Generation Justice platform, where we have also said that technology shouldn't just be used to automate paper-based processes. We can use technology to transform the justice system itself. Thank you very much for your remarks. Next, we'll move to Mr. Mistry for his introductory remarks. Over to you, Mr. Mistry.
Yeah. Can you see me? Because I can't see you. So it's again very interesting.
Just start
yes,
speaking,
so,
and I think the camera should.
yes. Yeah. So that's what we've been trained for. Okay. Thank Justice Nambiar, Harish, Leah, and all my friends. Thank you very much. I'll basically, there's this question
just
that is
1
always
minute,
asked me.
Mr. Mistry. I think your camera is off. We can't see you.
Is
Just
it
check.
on now?
You can check.
Either that or Leah has a monopoly over this.
No, not at all. Just speak,
Yeah,
Mr. Mistry. It should start automatically.
Yeah. I don't know why it's saying off. Anyway, okay. So as I was saying, there's a question in sociology where they always asked that man is a social animal. Okay, that used to be a very standard question. I think that that question in times to come is going to change to: is man a virtual animal? I think that's something that we're moving to, and this is an interesting time that this has happened. I would I mean, my experience as a lawyer who's practiced both in India and internationally, I think the big difference that I immediately found both on the use of not only video conferencing but technology in court. I mean, and I'm going to include live streaming in this, and yes, very much transcription, is that the process that we saw outside of India, and again, it's not rocket science. It's something that's evolved over there over a period of time, and therefore all the I mean, this reminds me of when we had you started with a landline, then you went to a pager, then you went to a cell phone, and now satellite phone. So I think as technology grew, you just adapted yourself, and technology became an aid rather than an hindrance. So what happens is typically when we went into
Mr. Mistry, I think is currently disabled. Could you please enable the camera? It's on the left hand side.
yeah, it's on.
Still, currently, I'm not able to see you. I think there must be some technical issue. Sorry to interrupt you, sir.
I request everybody else to just mute themselves.
I don't know, for some reason okay, it's just coming a video off. So the audio is on. I can see that. Anyway, I'll continue because time is of the essence. So yes, so when you actually went into a court outside of India, in a place where it's either totally virtual or what we now call a hybrid system, what you realized was that the entire process was seamless. You didn't realize even for a minute that you were being recorded. That's a great step that they've actually evolved. So there was pin drop silence in the court, and also for example, I know you mentioned Canada. I've done a lot of work in Canada. Even accents were not a problem. I mean, you had somebody who was, say, like an associate who was of Chinese origin. I mean, the plaintiff, say, is of Indian origin, but with an accent, and say the judge is of Caucasian origin. So you had different styles, different accents. That was also not a problem. And the other important aspect is majorly time management. I think that was very, very evident in court. So you had synopsis, you had briefs, which were very, very clear. You handed them over electronically also. So you didn't have this problem of, I will submit it subsequently in point of time. No. And you were given a time frame. And you said, okay, within 15, 20 minutes, you had to, say your piece. You were asked questions, and matter was over. I think they've really managed to do that, to the T. And I think we need to incorporate all that. I actually look at this at the stage that we are just now as a, we always say, it's we talk about judicial reforms. I think this is an integral part of that judicial reforms, because we are finally getting transparency in our proceedings. And by transparency, I mean your entire court proceeding is recorded. I mean, yes, I was a part of what is now called Swapnil Tripathi and others in the Supreme Court in that case where we argued for. And I'll just spend half a minute of saying we were trying to find out where in the common law system, I mean, India was part of the British Empire, was transcription used. And it was a eureka moment when I found that in the famous Bal Gangadhar Tilak's case in 1908, after the judgment was recorded, in paragraph 27 onwards, there was transcription. So we had transcription, and it's very rare to find transcription being incorporated in a judgment itself. I mean, we don't find that in the West today as well. So that was unique. I don't know really. I've asked several jurists, several people across India. They've not been able to give me an answer why it disappeared post-independence. Maybe because the jury system went and things like that. But can you imagine the amount of fabulous arguments that actually so many great counsel across our great country would have done? I mean, constitutional matters, etc. And we have no record of it except, the judgment. That's it. So I think that is something that needs to come in. And now let's be honest that after this particular order, that's the law. The question is only of implementing the process. There are, 3 or 4 sort of issues that are of great importance. One is that, video conferencing, live streaming, transcription, it's all comes in one package. So you have audio and video recording. The order that, for example, gets passed. Look at the International Court of Justice, or look at the UK Supreme Court, for example. Within 2 hours of the matter being heard, morning session or afternoon session, the entire transcript is put up on their website. I mean, you could see what, for example, happened in the Kulbhushan Jadhav case, which I was following that more to see how they use technology. And then by the evening or at the highest the next day, the entire, video proceedings was also put up on their website. Now, I think this is again something that, can very easily be done. I mean, there's no difficulty at all. And, we can have this across all our courts from, in fact, honestly, I think it's from the lowest level for tribunals, district courts, etc. This will be very, very useful. Translation, interestingly, can also be done instantly, which is also a great, step in the right direction, because quite often, we have issues that regional languages, and how do you sort of translate into into English, which is the language of the higher courts. I think that's also that can, very, very easily be done. The way in which this needs to be introduced, and I would like to advocate that, is we must bring this process as a part of legal education now. Every student of law must now be familiar in, whether you call it moot court, mock courts. They must have the ability to be able to record themselves and to hear what they've said. And that's very easy. It must be done, and prepare yourself that way, for not only what you're going to do within India, but tomorrow, if you are called upon to visit a court outside of India and, with the leave of that court, even argue, then you should be, the preparation is done like this. I mean, it would have been great, for example, if somebody had actually prepared Justice Nambiar for something like this. He would not have had that 10-15 minutes of consternation. So I think that's the way forward. And as far as the the DAKSH document is concerned, yes, I completely echo what Justice Nambiar has said. I think it's an amazing document. I think this would be useful not only from within India, but I think even in countries like the West, where, for example, the US Supreme Court has sort of started. I mean, they were against the whole aspect of recording, and had this telephone conversation. You have very interesting systems there for motor vehicle and traffic offenses. You have something where the court grants you TeleBail. It's they call the judge at home on a telephone. He comes on a video screen. You talk to him from the police vehicle, and he grants you bail that way. So I mean, it's fascinating, in the way in which several of these systems can be used, and of course, I think we are going through an ad hoc system. We will improve. We hope that the rules are made as quickly as possible. The rules also should be uniform. You can't have different rules for different systems. That's probably something that the courts need to be a little careful about. And yes, and publish it, put it out in public domain, and let everyone, including the media, who always has a problem. You have cases reported not properly. Now there is no question that he said or she said, or all that is out. Exactly who said what when. I mean, if I can go back to the 1908 judgment, I know what the judge said, and what I mean, for example, what the foreman and the clerk said in 1908. Isn't that remarkable? So yes, congratulations to DAKSH, and I think this will be very, very useful. Thank you.
Thank you, Mr. Mistry. Those were very interesting insights, especially the references to practices in other jurisdictions. Over to you, Harish, for your introductory remarks. Mr. Mistry, if you could just exit and join again, I think we'll be able to fix the camera problem. Over to you, Harish.
Thank you, Leah. Now, I want to make only a few points because I think Justice Nambiar and Mr. Mistry have commented on most of the other points that are relevant today. And I was particularly intrigued to hear the experience that Justice Nambiar had when this process started a few weeks ago in the Kerala High Court, just like all the other high courts. Now, I'll make 3 or 4 points and then spare some more time for the other panelists and for questions and answers. The first point I would like to make is that just give a bit of background as to what we at DAKSH have been doing over the last 12 to 14 months when this next generation papers started coming out. One of the first things that we envisaged is moving a lot of judicial processes online. And when I say online, I don't mean everything is online. It is to change the nature of the computerization project that the judiciary has been doing until now through the e-committee and the ecourts.gov system. And Justice Nambiar rightly pointed out that there are processes that were paper-based, that were set RCPC and the attendant rules and the CRPC and the various rules, the procedural rules that including the Evidence Act, the rules that the courts follow are based on a procedure that we have followed for about 150 years. And that is that those rules were made in an era when there was no form of computerization and online technology available. So we are now at the cusp of a dramatic change in technology usage, not just in courts, but in society as a whole. So when this dramatic change in society is happening, what should the judiciary do? So this was the background in which we started writing these next generation judicial papers. But the last 4 to 6 weeks, an unforeseen event that nobody could even imagine, I think has forced people to adopt to technology because they didn't have a choice. So 2 points again I would like to make. One, I am so happy as a practicing lawyer and as somebody who believes in the rule of law. I think we are so happy that the courts have reacted so swiftly to make available the judicial system to the litigants and the needy, because the courts can't just go missing in a democracy that's governed by rule of law. Courts can't go missing. But what has happened is, because of the technology challenges and because of what is available, not all courts are accessible at the moment. A few courts are accessible at the moment. So it shows how unprepared we were to use technology. Even the limited use of technology has happened because the tools are so easily available. But what technology has been used is merely for hearing of cases. And as Justice Nambiar pointed out, filing and hearing is what happened. Now, that is only a small portion of the overall judicial process. So while our seminar today, our webinar today is titled video conferencing, I think we need to look at the entire judicial process and see how much of it can be moved from a paper-based system that is based on rules that were made about between 75 to 100 years ago. Now, we cannot let the previous century dictate what needs to happen today, because we are governed by a different logic and temperament in the way public systems are functioning. Now, having said that, so that is the need to move. So move to processes that are not paper-based, but to technology-based, which should help the ultimate goal of the justice system. And I had written about this, long ago for a Kannada magazine, that merely moving from one system to another is not helpful. The goal of the justice system should be kept in mind. And when this move is happening, enough reforms should be carried out that actually enables better access to justice and better processes of the judiciary. So if we keep these two things in mind and then ensure that this digitization process happens in a phased manner, then I think we will be okay. The last point that I want to make is not to forget the promises and the pillars of the justice system, like concept of a fair hearing, concept of a public hearing, concept of an open court mechanism. There's a reason why we have open courts, just like we guarantee fair hearing, just like we guarantee natural justice. So all these things should not be compromised in the name of technology. Like one of the earliest adapters in the Indian judicial system of video conferencing has been, to present under trials who are in prisons, to present them to the magistrate via video conferencing from the prison itself and not bring them to the magistrate's court. Now, various rights activists have raised questions about that process. They're saying it causes denial of some rights to the under trials, and that is still a question that is open. So, in our zeal for technology, we should not compromise on some of the basic principles that the judiciary stands on. At the same time, I think we have reached a point where we don't have a choice but to move forward. We can't be caught as the judiciary has been caught like now, where while yes, certain cases have been heard, the volume of cases that gets heard in the Indian judiciary every day, and the injustices that people suffer because of a lack of access to the judiciary, should create a warning sign for all of us. So we should use that. I mean, great and dramatic changes happen because of certain instances, although that instance may be very, very small. While I'm not calling the COVID-19 a small instance because it's created havoc across the world, I think we should seize this moment and try to make the changes that we want to. And I'm really happy to see how the judiciary has reacted, particularly the High Courts and the Supreme Court. And yes, there have been problems, but I think it can be overcome. One more point occurred to me. Sorry, there have been a lot of newspaper reports and articles about some lawyers being unhappy with the video conferencing. I can understand as a practitioner why a sudden move to video conferencing would probably cause a bit of chaos and cause some sort of uncertainty amongst the most important stakeholder in the court system, which is the lawyers, because they're present there every day. But I think, as Jamshed Mistry said, I think there's need for an education of how the process is going to work. So I will, okay, the point about the transcription, I don't think we said transcription is a low priority. I think we said in terms of how we move things and what should be built first, I think we said transcription can come towards the end. We were prioritizing other things, but transcription is an essential part. I am part of another organization that has built an end-to-end online arbitration platform, and there the entire thing is being recorded and transcribed, all hearings. So I think that's, I just want to clarify that. I'll stop there. Thank you, Leah.
Thanks, Harish. That was very informative. As you've rightly pointed out, we are at the cusp of a great transformation in the judiciary, we believe, because of technology. And it probably means that we will actually change our perception of what a court is. I mean, do we view a court as a place or as a delivery of a service? So I think this move to video conferencing and later on to virtual courts, that will change the way we think of courts, which is right now as a physical space. We'll start our discussion now. For the audience members, if you have any questions, please write them in the Q&A tab, and we will ask those at the end. Please also mention which speaker you want to address the question. So we'll begin with, so should video conferencing be made a default mode in certain cases? Like we had mentioned before, if the witness is outstation or in POCSO cases, should it become a default mode in those kind of cases, giving the judge discretion to say otherwise? Justice Nambiar?
Yeah. Leah, I think, as Harish was mentioning earlier, a lot of the requirement of a video conferencing, for example, is kickstarted because of the necessity to do so. In our system, in our country, what you normally find is for any governmental organization to actually think of a change in this present system, because everybody is comfortable with the status quo. To actually get any innovative technology kickstarted, you have to have something like this coming up. Where take for example the pandemic itself, we had to have access to justice, and that had to be achieved without anyone moving from their homes, because we had to equally pay importance to the social distancing norms. Now, when you talk about both these, obviously video conferencing is the one that comes to mind, and we responded by kickstarting that program in the High Court. Now, when you talk about a category of cases, I mean, I would go a little further. I would say that we should have video conferencing as a viable alternative to the present system. In other words, you have the video conference, the regular courts functioning in particular instances, and not necessarily particular category of cases. Say, for example, you require a hearing, and there are two outstation lawyers who are coming up. Now, what we find in normal courts is when you take, for example, a writ petition, you could have lawyers appearing on either side coming from outside the state, and say the lawyer for the petitioner is coming from Delhi and the other lawyer for the respondent is coming from Bombay, and we are holding the hearings in Kerala. Now, normally when outstation lawyers come up for a case on a particular day, we would have given that date on the request of the lawyers. This is purely from the judge's perspective. The lawyers would therefore come on that particular day, and as luck would have it, we would have the board full on that particular day with some other case which has been filed urgently. Now, who do you give the preference to? The urgent case or the ones where the lawyers have come from outstation? In scenarios like that, probably we could use the video conferencing procedure for allowing the parties to, in those cases where the outstation lawyers come, we could defer the hearing to a later time on the same day, maybe even after court hours, where the lawyers would not have to travel from Delhi or Bombay, and we could have a video conferencing hearing, and at the same time deal with the urgent case that was filed in our court on that day. So when you talk about the various options available with video conferencing, you're not confining it to any particular category of cases. Secondly, the category of cases is also equally important. For example, as you pointed out earlier, certain cases like POCSO cases, where you would want the witness, the minor, to be shielded from the other witnesses who would be called to court. In those cases, definitely video conferencing is an option. And so are cases where you would go for in-camera proceedings. There again, video conferencing would, I think, solve a lot of problems which we face today in the physical courts. Yes, Leah?
Mr. Mistry, your views?
Yeah.
Oh,
Can
we
you
can
see
see you
me?
finally. Yes.
Fantastic. So I think I'd like to take what Justice Nambiar said a step ahead. I think, and the best example is your television channels. You have people coming into the studio. You have who can make it, who are in the vicinity. You have others who sometimes are in the studio but in another room. And and on the video wall, I mean, they do this every single day. So I think this is the simplest. You can then move from the regular cause list. You can immediately switch over to the video. You can get the parties in, and they won't waste their time traveling. It'll be a great sort of environmentally friendly. And so many other aspects. And I think importantly, there will be exactly how, for example, you have outside of India, when a case is listed, say 3 months down the line, except I think if somebody, passes away, there is absolutely no question of an adjournment. I think this will clear up a lot of, backlog that we have. I mean, once this is institutionalized. So I think a hybrid system, even once everything is set up, would be fantastic.
Harish, your views?
Yeah, so I think Mr. Mistry and Justice Nambiar have covered most of the points, but I would like to take this opportunity to mention two things that at DAKSH we have always used. One is judicial time, and two is certainty of hearing. Now, the most precious commodity in the judicial in the judiciary today is judicial time, right? Because the judge needs to spend his time efficiently hearing cases that he needs to hear with enough time for him to come to a decision. Right? Today, our courts are on most days quite chaotic, and it goes back to what Jamshed just pointed out, that frequent adjournments. So you have 100 cases, 120 cases listed sometimes before a judge, which causes chaos. So video conferencing and moving other processes to technology-based processes will ensure that we make the most of judicial time, and that precious commodity is used properly. The second point is certainty. I think certainty of hearing is what is missing in our judicial system today. So if I have a case in court today, whether the example that Justice Nambiar gave of an outstation lawyer or a local lawyer who is prepared a lot, when I'm entering the court, I don't know what is going to happen. I don't know whether my case is going to be heard for sure, because either the other side lawyer may not be there, or the board is full, there are some urgent matters that have come up, or the judge may say, okay, I'll hear you for some time today, but I have to dictate a judgment. Or the case could go on. So there are 3 or 4 possibilities, which causes a lot of uncertainty in the system. So unless we address this, both certainty and judicial time, And the use of technology, including video conferencing, is going to address both these issues. I think we will, we will face this problem. So we should look at technology as a tool to help all of us, rather than as something that is being imposed on us.
Thank you, Harish. Transition to online systems always face resistance. It's not just in the judiciary, in every sector we've seen that. And already, I think we would have all read about lawyers in Rajasthan saying that they were muted and therefore they thought they didn't get a fair hearing. What could the judiciary do to make lawyers and litigants more comfortable with this transition to online systems? Justice Nambiar?
That's confined to video conferencing modules. you hear those complaints even in our physical courts on a regular basis. And I think it's pretty much something that is controlled by the presiding judge of a court. You could, it all depends on how the judge conducts his court. So when a lawyer comes before you and he makes his submissions, the two things that I, for example, ensure in my court is one, that the lawyer is heard, and two, if I were to dismiss his case, then I would tell him why. I found that works pretty much in my favor and to the satisfaction of all concerned in my court. Now, it may be different for another court. So it's a matter of perspective as to whether a lawyer finds a hearing to be fair. But at the same time, I feel that if there is a live streaming of the entire proceedings, then you're bringing into the video conferencing module an aspect of public hearing, where there is a transparency of the judicial proceedings, and therefore which acts like, as they say, sunlight is the best disinfectant. Court proceedings, as long as they are transparent, I think would do away with a lot of the arbitrariness which people complain of in the course of hearing. I don't think technology is something that has to be viewed suspiciously by anybody, any of the players, either the judges or the lawyers or the litigants, because the judiciary has to move together with the changes in society, and that is how our laws have to change with the changes in society. When you're talking about almost everybody in the streets having a mobile phone and access to the present technology, there's no reason why we shouldn't change one aspect of our lives, which is access to justice and accessing the judiciary through a medium that is that most people in society are comfortable with. So I don't think the fair hearing or the complaints with regard to fair hearing have anything to do with the technology that we're going to adopt only. It is something that is a matter of perspective, and it has to be dealt with by the judge concerned.
Mr. Mistry?
Yes, I'll give you the best example. There was in the Kulbhushan Jadhav case, one of the judges from a particular country, he, sort of said that he was unwell and he had to leave the court proceedings. And it was very, very interesting to hear what the presiding judge or the chairman of the tribunal actually, through an order, said. He said, because the judge then said, since I was not there, I'd like to recuse myself. And he said, no, we don't think it is appropriate. We will give you the transcript and the video recording, which is there now and available. And it was as good as you were there in court. I think that's the perfect answer. I mean, that if everything is available, and even if you're not there in court, and I'm not saying that, this is what the International Court of Justice is saying. So this question of fair hearing is completely, taken care of, and you can look at it as many times as you want, today, tomorrow, day after, and come to, and therefore it'll be, no client can actually turn around and tell a lawyer that, this is what, that there was no hearing, or no lawyer can complain about this particular aspect. And of course, if for example, a court does, dismiss it without cogent reasons, then you attach that in your, your appeal. And, I was talking to the Attorney General of the state of British Columbia a while ago, and they were absolutely shocked. They said, "How do you file an appeal without a transcript?" We said, "Well, that's been the magic of our courts in India, and we've not done badly at all."
Thank you. Harish?
No, all I would say is that I don't think technology will face that much resistance, because technology has become the norm in our private lives, in our everyday lives today. So WhatsApp audio and video calls are very popular. So I don't think the resistance to technology per se arises from a fear of technology. I think the resistance to technology may be arising because there are other interests that people want to protect. I'm not necessarily saying they're vested interests, but it's just a familiarity. The familiarity of going to court, being able to stand up, seeing the judge, saying things to the judge, getting a response from him. That's a familiarity that's happened, a familiar thing that's happened over 150 years. So if you suddenly turn around and say, okay, no, you may not see the judge today, you'll see a screen. I'm sure that causes some sort of uneasiness as to whether the process will be the same as earlier. And Justice Nambiar was right. I mean, it all depends on how the lawyer or the litigant is heard in that matter. So I don't think, but I think that resistance to technology is slowly breaking down because technology has become so common. It's not an exotic thing that is available only to engineers or or scientists and things like that. I mean, we are doing this, Zoom calls anywhere and everywhere. I mean, families are talking to each other. So I think technology, because it's become so common, I think the resistance to technology may not be that much as we fear. Now, resistance to technology is not the same as demanding other things like uniformity, like rules around usage. For example, I think we have a great opportunity. We should do some audit of how the current usage happened across the courts in the country, what kind of rules can be done, improved, and each high court need not follow follow each other. They can each come up with their own solutions. So maybe it's a good thing. So I'm not so, and considering that I'm not a technology person, I'm not so worried about the resistance to technology as such.
Thank you. So physical courts operate on the principle of open courts, and if we move that to virtual courts, that would mean live streaming along with video conferencing. Do you foresee any privacy issues or security issues with that? This is Nambiar.
Tricky, that question, because as such, in a replication of the physical courts and a hearing given in physical courts in video proceedings, I don't see much of a privacy issue because you're not dealing with any kind of data which is not already in the public domain. Having said that, it may be a problem when you talk about specific types of hearing, like the POXO cases, etc., where you're not supposed to have a public hearing. Then the use of video conferencing technology would bring in privacy issues, especially when you're talking about data which is not under your control. So if you use a platform which is, of course, you can prevent the public airing of the public viewing of the proceedings by going into some secret meeting, etc. But the data that is captured through the software would still be in the hands of the owner of the company that provides you with that software. So those issues, I think, may need specific redressal before we actually switch over to the video conferencing module. Other than that, I don't think we have privacy issues with regard to the video conferencing. And more so I believe that, when we are forced to use the video conferencing as a mode for access to justice during a time, and then the question may arise as to which should take precedence, whether the individual private rights should give way to the superior or overriding public interest. As you know, the law in our country today is that when there is a conflict of fundamental rights, even if you take privacy as a fundamental right, and a fundamental right that is not absolute, when there is a conflict of fundamental rights, then the one that subserves common good, the greater public good, should be preferred. So, for the present moment, I don't think we need to be careful about the privacy right. But when you're switching over to the regular mode, or even as a regular alternative, I think we need to address that issue and be careful before we switch over.
Thank you. Mr. Mistry?
I think I have the same problem again, but anyway, I think the Swapnil Tripathi case has pretty much taken care of this. I mean, what can be live streamed and what can't. There are exceptions to the rule. I think that they have covered. This will certainly come into into effect once the rules are, for example, in matrimonial and other matters where privacy of parties, etc. Or so that's one. The other thing that also can, if say somebody says something which is unparliamentary or whatever, I believe it is possible for the judge to mute it. I mean that's sometimes does happen. Although in an open court system they do say that everything should be recorded exactly as it is. I'm not particularly concerned with data sort of leaking out and things like that, at least for our judicial system, unless it is something of such great national interest which is being argued in court. And normally such things are handed over in sealed envelope to the judge. So I don't think privacy in these different aspects is such a great problem. No.
Harish?
I agree with what the other two panelists said. I have nothing to add on the privacy issue as such.
Okay. I think we can take some audience questions now. We'll begin with a question from CM Joshi. I think this is directed at Justice Nambiar. What efforts have been taken by the high courts towards process engineering after technology usage has increased? So, process engineering to move from paper-based processes to technology-based processes.
We are, if you're talking of the High Court of Kerala, I'm presuming that that's what you mean. The e-courts, the High Court Computerization Committee, of which I'm an integral part, it's headed by Justice Pushtak. And for us, this has been
same problem. But I better stay on because in case there's a question.
Sorry, is that for me? Okay. The committee has actually, for us, this was the testing time, as it were. And when the lockdown period came into force, we understood that there was a need for the courts to function, because initially the judges had taken a decision, like all other courts in India, that we would close down. We had to close down our courts for the lockdown period because of the requirement of social distancing, etc. But having said that, and credit for this goes to the judges of the Kerala High Court itself, the overwhelming majority, in fact, it was almost unanimous. We felt that whatever said and done in our society, in our country, the courts cannot shut down. Civil liberties are at stake, and even during an emergency, you cannot forget the rights under Article 21. So our courts had to function, and left with that no choice situation, we had to improvise. And it was almost overnight that we got in this team. And we were already working on, having said that, we were already working on the computerization. We were on the cusp of launching a virtual court in respect of traffic offences, etc., with significant inputs coming from the E-Courts Committee of the Supreme Court. And the NIC also works with us in tandem. But overnight, we developed this system for dealing with other matters. And kudos to our IT team and also the computerization committee, which worked overtime to actually put this in place within less than 48 hours. And we started the division bench sitting almost immediately. So it's something that the High Court is generally pursuing, and now we're going to pursue it with a vengeance. And we are confident, at least in the High Court, that we will have a system of video conferencing as a viable alternative to the regular hearing, and at least to begin with, at least in some of the hearing matters alone, and then probably to the entire process from filing to the obtaining of judgments.
That's very heartening to hear. So the next question is from Siddharth. It's for Mr. Mistry. Sir, in your opening remarks, you mentioned that transcription brings transparency in the judiciary. In many districts in India, remand hearings of prisoners are conducted through video conferencing. There is an apprehension that rights of prisoners, such as legal aid, ensuring wellness, are not ensured in these hearings. One would agree that remand hearings are almost mechanical. Can transcription of remand hearings address this issue?
Oh, I mean, I think transcription brings in, even in a non sort of video recorded proceedings, it gives you an entire start to finish, an accurate, stating what the judge said, what the lawyer said, what a witness, the accused, anybody, whoever says anything is recorded verbatim. I mean that's the remarkable part of transcription. So I don't think in any hearing you can't get better than that. I mean, unless we get some AI or some technology even ahead of that. But till date, I think it's absolutely amazing. If somebody hasn't really seen how it is transcribed, you even have from your audio straight out today. Even the human interface sometimes is not required. And I think that in itself, so often, I'm sure, Justice Nambiar will also agree with me, the judges themselves don't remember what they said. You have 60 cases, you don't remember what you said in the first case, unless you, I know some of them, maintain diaries and things like that, but how would you actually remember what you said accurately? And I think that is fabulous, taken care of in any circumstances, including bail, out of jail proceedings and things like that. So according to me, it's a complete must, video or not.
Thank you. Here's an interesting question from Vivekananda1322. So he asks, as an active litigator, I'm still wary of the effectiveness of cross-examination in a virtual court, considering the fact that it has many facets to it, and more importantly, tutoring of witnesses. How do you propose to address this? I think this is for all three speakers. Mrs. Nambiar?
I don't know what if you're cross-examining a witness, surely there's going to be a marked change in the ambience of the court hall vis-a-vis the video conferencing platform. But if you look at it in terms of communication generally in society, I mean, gone are the days when you met up with a friend in a park and you had the luxury of talking to him, and the feelings that you developed just because you were talking to him in the park at close proximity. Today, everybody is on social media. So when you consciously changed over to interaction through social media, even in your daily lives, you're going to realize, you have to realize that sooner or later you're going to be shifting over to the electronic platform, even for other aspects of life. Cross-examination is important, no doubt, in order to the demeanor of the witness. But then these are things that you can see. It's not as though you're doing it blind in a video conferencing. So yes, maybe you will not be able to exert that kind of pressure on a witness. But then if you look at it dispassionately, then you're not supposed to be exercising that kind of pressure, exerting that kind of pressure on a witness. So maybe video conferencing is not a bad thing after all.
Thank you. Mr. Mistry?
I have seen, something that happens, for example, in where evidence is led before a commissioner, okay, even here and especially outside, where they record everything, even in close proximity. And we've had instances where a video conference takes place for that. What they typically ensure is that there is no tutoring, and video sort of it's like a CCTV camera that is operating that ensures that the witness doesn't get tutored. I think that it's very beautifully done. So there's no question of him being tutored by his lawyer or anyone else. So it's like it's sanitized. So there's no question of what the demeanor, etc. Yes, I think maybe the fact that he's not before a judge and therefore that kind of pressure of being in a court is lessened. But he's told irrespective that whatever you say could be held against you. So that's a small matter. So I don't think that's an issue. Now, for example, in arbitration, you have cross-examination, which is regularly done through video conferencing. So it's not something new at all, and it works. And in fact, sometimes this commercial stakes in arbitration is far higher than what you have in courts today. So it's fine.
Harish?
Well, I have 2 points to make here. So I was reading this morning that there is a virtual World Chess Championship that's going on, and there are different teams participating. India is one of the teams, and none of the players are together. And one of the concerns was, what if there's somebody else helping the player react to a move? So the chess.com, which is organizing this event, I think has prescribed certain rules, apparently, which ensures that they're able to see not just the face of the participant, but a bit more than that. So to precisely avoid this, which is somebody else giving instructions. So to that extent, I'm sure, as with the kind of video technology that we have today, there is the concerns about tutoring of witnesses can be addressed to a large extent. I'm not going to rubbish that concern at the moment, but I think it can be mitigated. If in a world chess championship it's being used, I'm sure we can learn lessons from there. The second point I would like to make is look at what is happening in reality in the courts today, right? Examination in chief happens today, cross-examination happens 3 months later, 6 months later, maybe 2 years later, right? And sometimes the judge who witnesses the cross-examination, who records the cross-examination, is no longer there when the judgment is to be pronounced. So whatever he has observed on demeanor and of the witness, unless he's recorded it, it's actually not taken into consideration when the judgment is being pronounced finally, because the judge who records the evidence and the judge who writes the judgment may be two completely different people. Okay, because they look at the average time taken for each case. Obviously, judges get transferred. So there are all these other issues that we are facing currently. So when we compare all of those issues in the larger picture, I think the issue of tutoring is a small point. If you look at it, I'm not, as I said, I'm not trying to say it's an inconsequential issue, but I think if you're looking at the whole system, then it's a small issue, and I believe it can be addressed as far as tutoring goes. The other points, I think both Jamshed and Justice Nambiar have addressed.
Yeah, and in our paper also we have examined cross-examination in the sections on due process and architecture. So we have looked at this issue. So this next question is for Justice Nambiar. This is from Ajit Joy, Advocate, Kerala High Court. He's asking, BC should not replicate formal court practices. What practices or procedure do you think can be excluded from BC?
No, as I said, the steps, I was only commenting upon the steps that we seem to be taking of replicating the actual physical court proceedings in the virtual court proceedings. And in that context, as Harish was also mentioning during the course of his address, all those procedures which are redundant today because of the switch over to the video conferencing module, I think do not require a place in our rule books anyway. Even a simple thing like, for example, a court fee, an element of court fee, for example, which is necessary for generating a paper-based judgment, a copy of a judgment. The copying charges, the stamp that you put on the paper. Now, these are all procedures that don't need to be replicated in a electronic module, and you can even have, for whatever costs that are incurred for providing the service, which I'm sure will be significantly less than what it is today in the physical world. We can always have a court fee suited for that. So what I was suggesting was that the redundant procedure we don't need to replicate in an electronic format or the electronic module. We can always do away with those procedures. I don't know whether this answers the question.
Thank you. We have a question from Supriya Shankaran. This is, I think, for all three. Given most lawyers in talukas don't have smartphones or laptops, what system can be put in place to increase access to them? Justice Nambiar, we can begin with you.
That I think is completely technology based, because for anything to work in our country, you need the infrastructure, and technical infrastructure is vital. I mean, even this is a problem we face. We don't need to go to the taluks. We can talk even about our towns and our cities. For some of the software that is used for video conferencing technology in most of the high courts, and even the Supreme Court for that matter, require bandwidth of a very high capacity. And sadly, we are not able to harness that kind of technology. We don't have it. We don't have a seamless, uninterrupted internet connection at times. So if you're looking at the efficacy of the system, you need the hardware and the software to match it, and also the support infrastructure like electricity and things. So that is not a problem caused on account of the change in thinking to switch over to video conferencing technology. It's more of a infrastructural requirement, and it's a reality that even in our cities and towns we don't have uninterrupted power supply, for example.
Mr. Mistry?
Yes, I agree that this is not the judiciary's problem. This is the problem of the government to ensure that I think it's not such an issue in the sense that people by and large and this is where I think you can, if there is an issue of you are on for example, if you are in a video conference mode, and then you sort of for some reason there is a technical fault, like for example just now you can't see me, surely there's a technical fault, but that doesn't mean that it's because it is probably, you can maybe that's the reason to actually give an adjournment in a particular case, because there is an electric failure. But I think all these for example, in the district court, now the district court would also have less number of cases as you go to smaller places. I think this can seriously be worked out in smaller places, and that's what I feel. Yes, power cuts in our cities have become regular features, but still I think it's not half as bad as handing out sort of computers or laptops and things like that, and maybe they should just every student law student who passes LLB should be given a laptop. Solve the problem.
Harish?
I mean, yes, internet, continuous internet access is a problem in the country still, and we certainly need to address that. But I think, there are workarounds around this. For example, there could be multiple locations. For example, bar associations and places like that could have video conferencing kiosks. And remember, I mean, not too long ago, we had STD booths at every corner in the country. They are redundant today, right? So I'm sure that enterprise will thrive, and if this becomes more often, I'm sure video phone booths will pop up across the country, and we will be able to use that. So I don't think we should be worried about. We should not put the cart before the horse. We should not say we will not move to. We will not use, or we will not make use of video conferencing or technology until we have this massive infrastructure. And I heard this concern on another webinar that was going on the same topic, or we need uniform infrastructure. Today, many district courts, district judges function under terrible, terrible conditions, but they're still rendering justice. That's not a reason to advocate poor facilities before you move to video conferencing. I'm saying you don't need to necessarily say, I will do all of this before I start it. I think we can go hand in hand, which is why, again, the paper that the team at DAKSH has put together clearly says the phasing and processes being moved online. So it is a concern, but I think one that can be conquered fairly quickly, I think.
We are running out of time. We'll take one more question. So this last question is from Paulos Abraham. I think this is for all three speakers. In terms of new technology adoption, should one draw a line against the use of social media as part of the judicial process? I was personally quite surprised to see a notice on the Kerala High Court website suggesting communication with the registry official as regards a particular aspect, not necessarily crucial, through WhatsApp. Justice Nambiar?
I personally don't see any reason as to why we should not use the available infrastructure, even if it is social media, for a legitimate purpose. It's as simple as making a phone call to the registry instead of the phone call you're using a social media platform. I do share the concern of the querist with regard to the transmission of other information over WhatsApp or other social media platforms. Yes, but again, his apprehension or his surprise at seeing these things on the Kerala High Court website, I'm sure he must have looked at the website during this lockdown period, and many surprising things have happened during the lockdown period. So I don't think there's any cause for alarm because we are treading very, very carefully and cautiously in our development of the IT infrastructure in the High Court. And for my friend, the querist, he can be rest assured that we will not do anything drastic, that would compromise on any security or privacy issue of the litigant.
Mr. Mistry?
I think this question of the use of WhatsApp for example, service of summons, etc., that was, I think, decided, and they said no, it's not to be used in normal times. So that's one. See, email, both to get a petition sort of served and heard today. I think that's a very easy and a much more sort of simple way of doing things. So that's that. And in fact, we did use that even a couple of weeks ago when this problem occurred for some students who was seriously disadvantaged for whether they needed to come and give their exams or otherwise. So an email was sent, and that was taken up, although the court was physically functioning. And the Chief Justice of our court in Bombay asked, so how, we haven't received anything. I said, no, we've served it to you on email, and he was absolutely fine with it. So that's not a problem. And I think, for example, in cases where in normal times, again, I'm just going back to Canada because I'm very familiar with that process. Where, say, a bail, a bail is granted, a surety doesn't have to come to court. What he does is he goes to the nearest Justice of Peace. The Justice of Peace actually calls up the court. They have a chat with the judge. He checks that the relevant documents for granting bail are there. The court is satisfied. They transmit it electronically to the court, and bail is granted, which I think will just cut out so much. That our criminal lawyer friends say that you have to come to court and do these things. So I think the use of technology for all these little nuances, except I think WhatsApp is perfectly acceptable.
Harish?
I actually concur with what Justice Nambiar said. I think social media usage should not be avoided because it is social media, but we should tread carefully. A concern that somebody else was sort of voicing was that, if you start making court proceedings that are on virtual court proceedings live, then will lawyers start playing to the gallery, and because they think they can win the public opinion. But my answer to that was, but that's happening even today because court hearings are open. Technically the public can go and view it. So I think we should not take our concerns too far. We all know the problems of social media, but we also know the advantages of social media, right? So I think it's a very, very careful line that we need to follow. And I'm sure when detailed rules come out on the usage of technology and these kinds of media, we will be sensible about it. Because even if we look at it, earlier in all our sort of notice provisions today, although they're outdated today, for the period when they were first started, there were advancements that on that day. Sending by post or sending through different means of service was something that was an advanced method of service. So I think we should not worry about it. We should embrace all the kinds of technology there is, but be careful about what we use it for and be responsible about it.
Thank you. We've run out of time now, although there are lots of great questions, we won't be able to take them. A huge thanks to all three of our speakers. This has been a great discussion. It's definitely helped us at DAKSH to gain insights into our own research. Thank you to the audience. Lots of great questions, as I said, but unfortunately we don't have time. I'd urge all of you to read our draft paper. It's on our website. And send us comments. You can send comments to info@dakshindia.org. Also, follow us on social media. We are on Facebook, Twitter, and LinkedIn. Thanks again. Stay safe. Good night.
Thank you.
Thank you.